Committee, can we everyone a copy, please?
Yes.
This is the testimony from Daniel Richard.
Good afternoon. May it please the honorable members of the Executive Council, my name is Daniel Richard. I'm here to oppose the nomination of Dan Edwards to the bench for the following reasons. The Constitution of New Hampshire, Part 1, the Bill of Rights, Article 35, is the standard by which Attorney Edwards should be judged here today. It is the private right of the people, and that all of you is sworn an oath to uphold and defend. Therefore, it is your duty to protect this right. Article 35 says, it's essential to the preservation of the rights of every individual to life, liberty, and property and character, that there be an impartial interpretation of the laws and the administration of justice. It is the right of every citizen to be tried by judges as impartial as the law of humanity will admit. It is therefore not only the best policy, but for the security of the rights of the people that the judges of the Supreme Judicial Court should hold their offices as long as they behave well. In order to maintain public confidence in the people, it is essential to the subject in an unfair contest with the state and its vast resources to be assured that there be an impartial interpretation of the laws. Public confidence in our own form of government is at an all-time low. Appointing people to the bench is a matter of great importance and quite possibly the Executive Council's most important constitutional duty. The people must have faith that the judges who are employed by the state are as impartial as the law of humanity will admit. I don't believe that Attorney Edwards meets that standard. When the judge sits in judgment of the subject and discovers that the state is wrong, we the people must be assured that our rights must always be protected and not swayed by politics or favoritism, as Attorney Edwards has done in my case. My personal knowledge of Assistant Attorney Edwards, or Assistant AG Edwards, comes from the result of my filing a lawsuit over my voting rights. Attorney Edwards represented the AG in the Secretary of State's office and is lead counsel in my case. In Richard v. Saloon, which is now before the Supreme Court, I claim that the current absentee voting statutes, aka mail-in voting, and the use of voting machines to conceal illegal, uncertified absentee ballots is repugnant and contrary to the Constitution of New Hampshire, as such actions are state-sanctioned ballot box stuffing. Having knowledge of the conflict between the statute and the Constitution, Attorney Edwards did nothing. The lawsuit accuses the state of violating my rights, and the defendants are accused of official oppression under state statute for violating the voting laws of the state. The defendants have not answered or denied the criminal complaint, yet Assistant Attorney General Edwards did nothing. On April 5th, 2020, just recently, 2023, a report was presented to the Ballot Law Commission. This is the report. Who voted 4-1 to refer the deficiencies and violation of state voting laws to be presented to the AG and the Secretary of State's office for their review. Although the report does not make any accusations, it does, however, contain evidence of violation of state and federal voting laws. And with evidence mounting, again, Attorney Edwards did nothing. What am I talking about? What is Attorney Edwards concealing? Let me explain. Please look at the proper affidavit, Exhibit A, first page. You'll see there that you have the Part 1, Article 11. There's 2 exemptions to it. You're a registered voter in the community that you're registered in, and you'll be out of town and make the appropriate application. Or you're physically disabled. The key is the bottom. Look at the very bottom of the page. That's a certificate. Okay? There's enough lawyers, and you're an attorney, anyone will tell you that an affidavit is something that is certified in front of an official authorized by law to do so. That's not happening. So to continue. This has been going on since 1979, by the way, which means no one here is even lawfully elected. Let me explain. Please flip over to the other ballot. Flip that page, go to this other side. Look at the envelope. That's a current absentee envelope. There's no certificate on it. You can't self-identify a return envelope and call it an affidavit when there's no witness. I don't know how you come to that conclusion, but that's the issue here. The Secretary of State is working with the AG, with the AG's oversight, caused to be printed, so they're responsible for printing these envelopes, okay? They printed them under color of state law, and they're defective. They're defective for that reason. And this is a violation of the 14th Amendment. Why? Because it's not equal application of the law. When you look at the voting statute, 659:30 says very clearly that any affidavit required by an election law statute must be accompanied with a certificate of an official authorized by law to do so. It's not there, it's missing. It's been missing for a very long time. I won't bother explaining it for the purposes of consolidating time, but that's the issue. This is malfeasance of office, because here's the problem. If you take an absentee ballot, and the original process created for this was in 1942. We created absentee voting by an amendment to the state constitution. The rules that were put in place were very, very simple. You took your ballot, you went to a public official authorized by law to do so, who would then witness, one, that it's not even marked, the ballot's not marked, two, that the person would fill in that ballot in the presence of an election law official, and then when he got done, he would go ahead and they would both sign that inner envelope and certify that it was in fact the individual who's attesting to the fact that everything is true and correct. That didn't happen. It hasn't happened. It isn't happening. So when you take that and you take that ballot, see the statute law, and here's the conflict. The statute requires that an affidavit be executed. The second part of it is the moderator is supposed to make sure that if it isn't lawfully executed, he's not even supposed to remove it from the ballot. Excuse me, he's not even supposed to remove the ballot from the envelope. He's supposed to put it in the bin to be disposed of, and that's the next thing. The evidence rules cover that it's supposed to be put aside when all the other ones are going to be disposed of. But that's the underlying issue, and so that's why I opposed that nomination, because as her own testimony, she's been at head of election law for 26 years. How do you not know that? How do you not know? How do you continue to call? And you mentioned about percentages. Let me give you the hard numbers. Bill Gardner told me that the 2014, 16, and 18 elections had an average absentee turnout of 4%. You know what we got with 2020? 32%. So back to your comment about it being, the gold standard, I have to respectfully disagree because of this issue. I know, by the way, I agree with you that all the volunteers that work in the state, these are great people. That's not the issue. The issue is the training and the oversight. Why are the most important people involved not doing their job?
So, briefly, I really got that wrong very
We
fast.
agree that 2020, there's irregularities. I'm talking about the New Hampshire growth and the elections that have gone on before. 2020. So 2020, there was some hiccups. And I agree with you with this certification of custody ballots, because there is so much potential for abuse.
Especially now that the courts have ruled that the signature verification is no longer, that the average moderator lacks the skill set to be able to examine the signature and determine that I'm going to deny a voter his right to vote. And so they've struck that down, making this provision even that more important, because someone has in fact witnessed. Look, the rest of us do, right? We show up to vote, we present our ID, we get the ballot, we go to the booth, we do our thing, all under the oversight of a public official authorized to do so. That's why I say it violates the 14th Amendment, because now you're allowing a different standard. That's key. You can't use a different standard. This is where you get into the federal election law. You can't use a different standard for one group of people, mail-in voting, and apply a different standard to the rest of us. And that's what I'm arguing.
Thank you, Dan.